with the roll call. The meeting will come to order. Secretary, please call the roll.
Chairman Briggs.
Present.
Representatives Carroll. Here. Donahue. Here. Hanbidge.
Designation.
Hohenstein. Here. Howard.
Designation.
Kenyatta.
Designation.
Kincaid. Here. Mays.
Designation.
Pielli. Here. Rab.
Designation.
Sanchez.
Designation.
Schusterman.
Designation.
Williams. Here. Chairman Kaufman.
Here.
Representatives Bonner. Here. Ecker. Here. Ham. Here. Clunk.
Designation.
Ledbetter. Here. Allett.
Designation.
Rigby. Here. Rowe.
Designation.
Schemmel.
Designation.
Shalaba.
Having established the presence of a quorum, the committee is in order, and we will proceed with today's agenda. The first and only bill on today's agenda is House Bill 2628 by Representative Miller. I'm going to go at ease. I believe Representative Miller is walking to the hearing room. We're just going to pause until he arrives so he can discuss his bill. Thank you, everyone. We're going to get back to order. Chair, what do you sit up front? Whip Miller, you'll be recognized for some brief comments on House Bill 2628, followed by counsel for any additional explanation. When you're ready, you're in order. Thanks, Whip.
Thank you again, Mr. Chairman. I appreciate the committee's consideration today. Obviously, we've done a version of this before. We've talked about this a bit, about the need for juvenile justice task force recommendations to be adopted. Recently, the House passed 2 of the, I'm going to say roughly 35 recommendations that the task force passed with consensus or more support. Those recommendations embodied, I think it was Senate Bill 169 and Senate Bill 170. And they were 2, I'll just say modest step forwards, which I appreciate. The challenge a bit here is that the need for reform, as outlined by the bipartisan, bicameral task force that we created almost 4 years ago, or 5 years ago, is great, and we have a lot of work that needs to be done. The recommendations now, or what is embodied in 2628, is an expansion. I believe if the committee were to check, there would be recommendations that would be like 15, 16, 21, 22, and 28 of that task force. There are 2 additions that are put in there that were also embodied in the larger, more omnibus juvenile justice review or bill that we offered to the committee for consideration before. And those have to do with disability related issues. Those obviously are some things that mean a lot, I think, not only to me personally, but to the world when it comes to juvenile justice relations. We know that too many states are showing that somewhere between 30 and 80% of the kids who are in the juvenile justice system, depending on the state and depending on the evaluation, they are kids with an IEP. Those kids with an IEP are there for a multitude of reasons in the IEP. Some of them could be on the autism spectrum. Some of them could have a variety of other diagnoses that are impacting how they learn. One of the challenges that we find in the juvenile system is the sort of lack of flexibility or understanding at times, despite the best interests of those professionals who are working in that arena, to be able to develop a juvenile justice system that addresses those needs in a more productive way. One of the challenges that I think was not reflected in the report so well was in relation to failure to adjust. For those who are aware of those terms in that process, in essence, it's a probation violation aspect talking about how a young person is not well suited perhaps for a placement that was done. We had a lot of FTAs when I was a county solicitor that were brought up before us. And one of the things that we found was that the system where we were sending our kids to were not really well tailored for the kids' needs, the behavioral health needs when we were sending the kids there. So they would come back for an FTA, and they usually would come back within the first, say, 2 to 6 weeks. The challenge that came up with that was twofold. Number one is we often found that the FTA was based on some type of behavioral challenge where either because they weren't told ahead of time or because their program was not well situated, we were not able to find that the proper supports were there for that young person to thrive in the first place. Then the second thing, which was often the most challenging part, was that we would find that a child who was brought up on an FTA and then adjudicated on that FTA would then be ratcheted up into a more restrictive placement, often because of those behavioral health issues. And for those who are more familiar with the ADA and special education law, we know that there are things that are done to protect, to recognize when disabilities are in place, and to not punish children in this regard because of a reflection of those disabilities. Well, that's what a manifestation determination hearing does. So what you'll see in this bill is the adoption of a manifest determination hearing that is reflective of what we currently do when it comes to IEPs and school discipline matters. It's nothing new. It's not created. It's just making sure that no child is punished because of a reflection or a behavioral issue that comes up due to their disability. So that's what we have added. We've taken those roughly 5 or 6 amendments, recommendations from the Juvenile Justice Bipartisan Bicameral Task Force, and expanded upon them in these bills. And we've added greater disability protection for what we know to be a system that is having more children with disabilities in it by far than our school systems have. The average school system in the state, you're going to run somewhere between 16 and 21% with an IEP. We know that these systems here, depending on the time, depending on the state, they are 2, 3, 4 times as likely to have kids with disabilities in this system. And we can't have them punished because of a reflection of their behavioral health or their disability aspect. And so that's what is embodied in 2628. Thank you.
Thank you, Whip. Council Claudius, any additional comments?
Thank you, Mr. Chairman. Just briefly, I would just note that the provisions in this bill basically attempt to follow the recommendations, which were consensus recommendations by the Juvenile Justice Task Force. Consensus means at least 2/3 of the voting members supported them. I would also note there is one amendment to the bill.
Thank you, Council. You're in order on Amendment A06007, offered by Representative Ledbetter.
Amendment A06007 changes provisions on restitution, provisions for removal of children from their homes for probation violations, and some dispositional review requirements, which are either in direct conflict or different from those contained in the task force recommendations.
Thank you, Council. We'll need a motion to adopt A06007 by Representative Kaufman, Chairman Kaufman, seconded by Representative Rigby. Are there any comments or questions on the amendment? Representative Ledbetter, would you like to discuss your amendment?
Thank you, Mr. Chairman. Yes, on the amendment, if appropriate.
You're in order. Thank you.
Thank you, Mr. Chairman. Mr. Chairman, Amendment A06007 seeks to provide clarity to points of concern within House Bill 2628. While myself and I'm sure my colleagues appreciate the intent of the maker of the bill, there seems to be opportunities that my amendment seeks to address in improving the language. The bill provides that restitution may only be ordered to an actual victim, and while that actual victim term lacks definition in the bill, the amendment removes the term actual and creates a definition for the term victim. This will be the same as the definition used in the Crime Victims Act. The term victim is defined by the amendment as a direct victim, a parent or legal guardian of a child who is a direct victim, a minor child who is a material witness to a murder, rape, or aggravated assault, or a family member of a homicide victim. In addition, the underlying bill allows courts to forgive unpaid restitution over the objections of a victim. This amendment provides that the court may not forgive unpaid restitution if the victim opposes the forgiveness of restitution, or the juvenile was adjudicated delinquent of human trafficking or a sex offense. My amendment also provides that the restrictions placed on the court's ability to order out-of-home placement only apply to a juvenile under 16 years of age. The bill currently restricts the court's ability to remove a juvenile from his or her home unless they were repeated violations of probation for an offense involving the threat to use a deadly weapon, or repeated violations involving the intentional infliction of significant bodily injury to a victim. Once again, this amendment removes the requirement that there may be repeated violations and serious bodily injury. The amendment provides that a court may remove the juvenile from his home if the juvenile absconded, the violation of probation involved an intentional and unexcused failure to adhere to recommended programming on more than 2 occasions, the probation violation involved assaultive behavior or a credible threat to cause bodily injury to another. Finally, the bill creates a rebuttal presumption that any commitment shall not exceed 6 months. This amendment provides an exception if the juvenile was adjudicated delinquent for a felony or sexual offense. The bill also provides that at disposition hearings, the court shall inquire as to the assistance given to the delinquent child by the probation department and placement providers when examining whether the child is moving towards satisfying the order of restitution. The amendment removes the requirement that the court make this inquiry with the probation department and placement providers. Once again, Mr. Chairman, while extensive, this amendment does seek to align with the intention of the maker of the bill and provide advancement in this very important area, as well as provide clarity to points that are ambiguous in its current form. Thank you.
Thank you, Representative. You mentioned the intention of the maker of the bill. I was hoping to actually see if you wanted to address the amendment in any way.
Yeah, only to first to thank the gentleman for his time in consideration of his amendment. Look, there's no doubt when it comes to aspects of victims, one of the priorities that we try to seek is how to give money back to the individuals who are those impacted. And the challenge that we find all too often, I think that's embodied in the original recommendations, is third-party insurance companies who then seek to find themselves to be qualified as a victim in a juvenile court and to seek restitution that way. One of the things that I'm sure the gentleman is aware of is regarding the civil opportunities for recovery that exist, both for third-party institutions to seek, but also to, when it comes to unpaid restitution, the possibilities that do go forward. The challenge that comes up is juvenile court is not meant to be adult court, nor is it meant to be a civil claims court. So both of those regards, the opportunities, we don't seek to, the bill does not seek to impact. If a third party wishes to pursue restitution aspects of what they would qualify to be restitution as an insurance company, perhaps they can do so, but they'll do so in a civil court and not seek to have a 14-year-old remain on probation for $4 a month payment as they, pay back, the money that the insurance company put as a possible business loss or anything else. So that's why I think the distinction was made. I also appreciate aspects that I think almost all of us would tailor a word choice differently here or there. The reality of it is that the first bill we tried did make larger changes. In discussions with the Senate leadership, they did not want us to make sizable changes to aspects of things with it. We sought to instead take the 2/3 recommendation that this task force created and literally put in as much verbatim language as possible to stay with this bipartisan, bicameral recommendations. So overwhelmingly, while I'm sure perhaps a good gentleman and I could both agree on a word choice here and there that we would seek to change, the reality of it is in order to try and find compromise with the Senate, we stuck overwhelmingly with the verbatim language of that bipartisan, bicameral, 2/3 consensus task force. And that's why I would suggest, with all respect to the gentleman, that that the amendment not pass.
Thank you. Any other comments or questions on the amendment? I am encouraging a no vote on the amendment. Secretary, please call the roll.
Chairman Briggs.
No.
Representatives Carroll. Donahue. Hanbidge.
Designation no.
Hohenstein. Howard.
Designation no.
Kenyatta.
Designation no.
Mays.
Designation no.
Pielli. Pardon me, Kincaid. Sorry, Mays was designation no.
Designation
Pielli?
no. I'm sorry.
Pielli? No. Rab.
Designation no.
Sanchez.
Designation no.
Schusterman.
Designation no.
Williams. Chairman Kaufman.
Yes.
Representatives Bonner. Ecker. Ham. Clunk.
Designation yes.
Ledbetter.
Yes.
Owlett.
Designation yes.
Rigby. Rowe.
Designation yes.
Schemmel. Shalaba. The amendment fails.
Thank you, Secretary. The amendment fails. We'll need a motion to report out House Bill 2628 by Representative Kincaid, seconded by Representative Donahue. Are there any comments on the bill? Representative Hohenstein, you're in order on the bill.
Thank you, Chair. I just want to make a comment on the impact on the disability community of this bill, and the representative's point that we have so many of our kids who have IEPs or who are already in a special education situation being placed into what is effectively a criminal justice regimen, and recognizing that at those early ages, the ability to distinguish between what is appropriate consequence and what is undue punishment is really a very difficult thing. And I think the idea of this bill, and one of the reasons why when I saw the amendment, I was also concerned, flexibility for an individual judge to look at an individual situation and consider all aspects of that situation, including the delinquent child, the person against whom that child might have acted, if any, and to be able to find a way to fashion justice that allows movement forward for all parties, I think is really, really a key. Because if we do that in a juvenile delinquent situation, we will then see the fruits for society as a whole by reducing the adult population that all of our children will become and be placed into. So I think the idea of this bill and the implementation of a joint bipartisan task force recommendation set is extremely, extremely valuable, and I think it's going to go a long way if we are able to get it enacted to making a justice system that actually does mete out justice and not simply retribution and punishment.
Thank you, Representative. Any other comments or questions on the bill? Representative Ledbetter. You're
Thank
in
you,
order on
Mr.
the
Chairman. Mr. Chairman, my question will be directed to council if in order.
bill. You are in order.
Thank you, Mr. Chairman. The bill provides that restitution may only be ordered for an actual victim, which is not defined by the bill. Council, can you point to the language in the bill that I can reference that will outline exactly what an actual victim is defined as?
There is no definition of actual victim in this bill.
Thank you, Council. In addition, if in order, Mr. Chairman, if I may, one more question.
Yes, you're in order.
Thank you again to Council. In the bill, Council, does the bill allow courts to forgive unpaid restitution even over the objection of a victim?
The bill requires that a victim be given notice and opportunity to be heard. If the court is contemplating that, there are some other standards as well.
But the forgiveness can still be determined despite the objection of the victim.
The bill does not require, or let me sort of back up. There is no requirement in the bill for the victim's position one way or the other. There's a notice and opportunity to be heard. And the court has to consider that, to consider the victim's position, obviously.
Thank you. Well, Mr. Chairman, in an effort to, again, collaborate and provide clarity to policy and legislation, as lawmakers, I'll look forward to the opportunity to collaborate with the sponsor of the bill in an effort to potentially offer some of these clarifying points that had been, but a moment ago, rejected in an amendment that ideally we'll be able to have prepared for the floor. Thank you, Mr. Chairman.
Thank you, Representative. Any other comments or questions? Representative Kincaid.
Thank you, Mr. Chairman. As I detach the microphone from its cord. I am the Democratic Caucus's appointee to the State Council for Interstate Juvenile Supervision. And one of the things that we continuously grapple with is the fact that there are no placements for detention for juveniles. And so the need to reform the way in which we are deciding to detain juveniles is critical at this juncture, because we don't have places for them. And so making a more concerted effort to be very diligent and very intentional about who it is that we detain and for how long we detain them is going to help with that burden. The other thing is we commissioned this task force, bipartisan, bicameral task force. If we fail to accept the recommendations of a group of individuals that spent a considerable amount of time putting together these recommendations, what are we doing? Why do we do this? Do we just do studies to make ourselves feel better, to say, well, you know, we put something together and there were recommendations and now we're gonna put it in a drawer and it'll collect dust and that's where it's at? Or do we actually listen to the people who have the expertise on this topic and apply those so that we can have a more just justice system, particularly for our young people? So I would ask my colleagues to be a yes on this, because this is just a verbatim application of some of the recommendations that have the most consensus of this group. So thank you.
Thank you, Representative. Any additional comments or questions before we do some closing comments? Chair Kaufman, you're in order on the bill.
Thank you, Mr. Chairman. We're hearing significantly about the task force, and it's important to note that the recommendations, while it was a bipartisan commission, let's not mistake that the recommendations, they were not unanimous. And while the commission, yes, was bipartisan, the recommendations were not a unanimous decision. And that task force was in 2021. And I live in a border county to the Maryland line. So we're on the Mason-Dixon line, as are, I believe, a couple of my colleagues here in the room. And after our 2021 recommendations, in 2022, Maryland actually enacted many of the recommendations that are in the legislation, and what I would say the problematic provisions in this legislation in 2022. And they have run into, as soon as, that was 2022, and by 2023, they had run into significant issues seeing what they did. And many of the changes that they found, there was an article that I found on public radio from the state of Maryland. And they've gotten to the point where they're saying some of the youngsters are laughing at the officers, saying that they know they can't do anything to them. The kids have already figured out the new rules, and they are choosing kids under the age of 13 in Maryland to be drivers for criminal activity. So now they have 11-year-olds with no licenses, no training, driving stolen cars at high rates of speed in Maryland. I'm concerned that some of these changes, without looking deep, you're going to be seeing, while I believe we all have concern that those who are juveniles and may have learning disabilities, maybe on IEPs, are not victimized by the system. Absolutely, 100%, I think we all get that. But with provisions like this, you could have criminal elements further victimizing these juveniles by pushing them to be the front people on very serious criminal activity. And it's important that when we do it right, and we see what other states have done that are similar and are not working for them. One of the legislators, Democrat legislators from the county of Baltimore, she said, "We thought that we had it all right, but I am an adult who can admit mistakes, and I believe that we need to correct it." And so I think it's important that when we do it, we get it right. We don't just pass things because they were in a report from 4 years ago and not acknowledging what other states have done and what they're experiencing. So with that, I would love to see something that addresses some of these issues, but this is certainly not the vehicle and certainly not the answer, and I will be opposing it.
Thank you. I encourage you. Yes, vote. Secretary, please call the roll.
Chairman Briggs.
Yes.
Representatives Carroll. Yes. Donahue.
Yes.
Hanbidge.
Designation, yes.
Hohenstein.
Yes.
Howard.
Designation, yes.
Kenyatta.
Designation, yes.
Kincaid. Mays.
Designation, yes.
Pielli.
Yes.
Rab.
Designation, yes.
Sanchez.
Designation, yes.
Schusterman.
Designation, yes.
Williams. Chairman Kaufman.
No.
Representatives Bonner. Ecker. Ham. Clunk.
Designation, no.
Ledbetter. Owlett.
Designation, no.
Rigby. Rowe.
Designation, no.
Schemmel. Shalaba. House Bill 2628 passes.
House Bill 2628 passes and will be reported as committed. This meeting stands adjourned. Thank you.